Welcome to 2023, folks. This is the first training of the new year, and I couldn't be happier to be having this particular training, not only because of the subject matter, but certainly because of who our presenter is today. For those who don't know me, my name is Alexis Alvarez. I am the Director of Statewide Training at Florida Legal Services. And it is my extreme pleasure to welcome you all to today's webinar, a deep dive into discharge upgrades. For folks who dabble in this type of work, you all know how confusing it can be, how difficult it can be, and how important this work is. So thank you for all that you do in the community when it comes to our veterans and our discharge upgrade work. And thank you for coming to be here today in community with us. So before I turn it over to our presenter and we get started, I want to go over some housekeeping announcements. First and foremost, this training was approved for CLE credit. I will announce that CLE code at the end of the training. I will also pop it into the chat, and I believe it will also come up on the screen as part of the slideshow. So don't worry, you will get that CLE code closer to the end. Additionally, an email will come out from Zoom within 24 hours with a copy of the recording of this presentation, a copy of the PowerPoint, and that CLE information. So if you miss it in the webinar, don't worry, check your inbox. You'll get an email from Zoom. Everything will be there. But of course, you can always email me directly if you don't see that in your inbox. And when we get started, I will put my email address into the chat. That way you all have it if you need anything. Second housekeeping announcement, closed captions have been enabled. If you're not seeing them, I believe you just need to click more and put show captions. I know Zoom updated recently, so if anyone's navigating the new update like I am still, feel free to reach out to me in the chat and I'll do my best to help you get situated. Third, questions and answers. Please feel free to drop your questions into the chat and or the Q&A. I will do my best to monitor both of them, and we will address those questions when our speaker is able to get to them. And I think the last piece of housekeeping announcement is just a reminder that this is being recorded. We're here from 12 to 2, so it is a longer presentation that we have here today. That's why it's a deep dive. And so if you have to hop off, if you have to go back, to put out the fires that you all are doing all the time, don't worry. You can hop off when you need. You will still get a copy of the recording. That way you can finish learning everything that you want. And so with that being said, I'll finish up with the boring stuff and go right into introductions of our speaker here today. Today we have Christy Bagalow, who serves as the director of the Veterans Consortium Discharge Upgrade Program, which reviews discharge cases and primarily represents veterans who received other than honorable discharge due to misconduct related to post-traumatic stress disorder, military sexual trauma, traumatic brain injury, and other related mental health issues. Christy is a Florida native and a triple gator, having received her BA, her MA, and her JD, all from the University of Florida. She has worked in the public interest field since her graduation from UF Law in 2010, including working for the Community Legal Services of Mid-Florida, the Ninth Circuit Public Defender, and Florida Legal Services as Director of Statewide Training. Christy has been accredited by the VA to represent veterans since 2011 and is also admitted to practice before the CAVC. Christy has represented veterans at every level of the claims process, from initial claims to federal court. She is particularly passionate about discharge upgrades, which can lead to life-changing outcomes for veterans, from access to VA healthcare to long overdue validation of their military service. I am so honored to be here with Christy, to support Christy providing this training. And with that being said, I will turn it over to you, Christy. Thank you so much for everything you do, everything you've taught me in life, and for being here today.
Thank you, Alexis, for that kind introduction. And thank you everyone for joining us for this first training of the new year. I know I almost said 2 years, 2 hours is a lot to ask. So as Alexis said, feel free to go back. Hopefully my screen is cooperating with the slideshow. And all good. All right, excellent. Yes. Hopefully technology will hold out for us. As Alexis said, I've been doing veterans work for a long time now. I love it. I'm happy to talk about it. I'm always excited when new people want to learn about this area of law and possibly volunteer for us. So I will get started here, and I'll try to remember to give us a break around 1 o'clock, as 2 hours is a long time to focus. So at the Veterans Consortium, we believe that our veterans, our nation's defenders, deserve the care, benefits, and compensation they were promised, and the best legal services free of charge to meet their challenges. So I'm really honored to work for this nonprofit. We serve veterans nationwide and actually worldwide in the Discharge Upgrade Program, and all of our services are free. So I absolutely love being able to work for a nonprofit that's totally dedicated to serving veterans. And here's a little bit about what we do as an organization. Our main line of service is providing veterans with pro bono representation before the federal court, which is the Court of Appeals for Veterans Claims. They always need volunteers for that line of service, so reach out to me if you're interested, and I will get you connected. My part of it is helping veterans who have less than fully honorable discharges. We will hear a lot about that today. And we also operate some veterans clinics, help veterans with naturalization, and have a women veterans clinic that is specifically run by women pro bono volunteers in service to our women veterans. Here is our big agenda for the day. And like I said, I'm really excited to see so many people who want to learn about upgrades. This is not my basic overview. It is more of a deep dive into the nitty-gritty of how to do these cases from start to finish. So we're going to talk about why discharge upgrades matter, who is a veteran, which is more confusing than you would think, types of discharges, a little bit about the VA character of service, although I do need to just make a training completely on that topic. So Alexis will remind me to do that in the future. The discharge review boards, brief preparation, the typical arguments we make, because like Alexis said, our focus is on helping veterans with mental health mitigating arguments, and then preparing the application and submitting. So it's a lot to cover. We'll probably have to hold questions until the end just to make sure I get through everything. I'll try to leave plenty of time for questions. And remember, if any of you are private attorneys or just interested in learning more about this area of work, there's always a need for volunteers. In our discharge upgrade program, there are not many attorneys or advocates who practice in this area of law, and there's a lot of demand out there. So a discharge upgrade is really important because it can affect pretty much everything in a veteran's civilian life. It can affect whether that veteran is eligible for VA healthcare, for disability compensation, for community veterans benefits. Getting a discharge upgrade also reduces the risk of homelessness and suicide. And for a lot of veterans, the most important part is finally having their service validated and being recognized as an honorably discharged veteran. Our upgrade program provides national and technically international pro bono legal representation to veterans who received less than honorable discharges due to PTSD, traumatic brain injury, military sexual trauma, or anti-LGBTQ policies, which we'll get into a little bit in this presentation. But I have another presentation I'll plan to do later this year that is specifically about helping LGBTQ plus veterans with discharge upgrades, because there are some special circumstances there. And our program is generously sponsored by the Disabled American Veterans Charitable Service Trust. So this is the process for our intake. When a veteran fills out our online intake, which is at the link at the bottom of the screen, we take a look to see if they were discharged other than honorable, which I'll explain later, or general discharge if they are survivors of military sexual trauma, or if they were discharged under Don't Ask, Don't Tell. So it's always worth a try to apply for our services. Some veterans are just not going to meet our qualifications, and we will still send them a really detailed packet of how to apply on their own. And then, of course, if we accept them into our program, we go through a whole process of requesting the records, reviewing them, and then connecting them with a pro bono attorney to file the case. And I forgot to mention on the last slide, it makes a huge difference for veterans to have attorneys or advocates represent them through this process. Discharge upgrades are really hard to get. The burden of proof is completely on the veteran. And overall, I believe the upgrade rate is somewhere around 20%, which is an average of all the different discharge boards. But when they have a pro bono attorney on the case, the success rate goes up to about 90% in our program. So you can really make a huge difference helping veterans in this area. First order of business is, who does the VA consider a veteran? So when a veteran shows up to the VA, what happens? The VA's definition is clear as mud. It is a person who served in the active military, naval, or air service, and who was discharged or released therefrom under conditions other than dishonorable. That's a lot of words. It's very confusing. As you'll see, the types of discharges, there is no other than dishonorable discharge. So oftentimes, unfortunately, veterans with other than honorable or lower discharges are turned away for VA healthcare. Often they're not supposed to be turned away, but no one understands these nitty-gritty details at the front desk of the VA. So that's why this work is really important, because there's a lot of confusion, there's a lot of stigma around bad discharges. In addition, veterans who are women sometimes don't self-identify as veterans. They may think they're not eligible for anything from the VA, maybe because they didn't serve in a combat zone, or they think they didn't serve long enough. So there's a lot of education that needs to be done out there. So I appreciate you all helping me spread the word on this, and feel free to share the recording. For those of you who are new to veterans work, this is the magical paper that summarizes a veteran's entire military career on generally one page. So there's a lot of good information on here, but there's also usually a lot of mistakes. Sometimes combat service will not be listed, and other things will be missing, but you can get a general idea of what happened during the service. So for our purposes, the main part is down towards the bottom where it says character of service. Our clients are going to have a general, other than honorable, or lower discharge, and I'll get into the differences there. Sometimes there's also a narrative reason of separation, which can be really stigmatizing. It could say misconduct, drug abuse, or it could say serious misconduct, or for veterans discharged under Don't Ask, Don't Tell, it may say homosexual acts. This DD-214 is the veteran's passport to VA services, to veterans' preference with employment. So you can imagine they wouldn't want to show those sort of details to a potential employer. These are the types of discharges. We usually see the administrative discharges. So the vast majority of veterans end up with an honorable discharge. It does vary according to branches of service, which I will definitely detail a little bit later. The next step down is a general discharge, sometimes called general under honorable. So you see how it gets confusing with that VA definition under other than dishonorable. There is no such thing on this chart here. And things get really mixed up, and veterans unfortunately just leave the VA and never come back. Other than honorable is the most common discharge that is accepted for our program services. That's where the veteran will most often be denied VA healthcare, compensation, any other VA benefits. Now with a general discharge, they're eligible for everything except for the GI Bill education benefits. So for any of you who have kids in college like me, you know that's a huge benefit. That can be really life-changing for the younger veterans who want to go back to college. If a veteran chooses not to go through the administrative discharge process and instead chooses to go through a hearing, they could risk having a punitive discharge. So the same kind of misconduct that could result in an administrative other than honorable, after going through the hearing, they're risking getting a bad conduct discharge, which just locks them out of everything. And as you can imagine, it's a big leap to ask for an upgrade from a bad conduct all the way to honorable or even general. So I do see that a lot. It's the same underlying misconduct could end up with an other than honorable or a bad conduct, again, depending on whether they choose to go to trial, essentially, depending on the branch of service they served in. We don't see too many dishonorable discharges or dismissals in our practice. So like I said, on that DD 214, there's some interesting narrative reasons that can be listed on there. And we always ask for that to be changed in the discharge upgrade process. Something important to remember, and anyone who has listened to any of my VA trainings knows that I always repeat, nothing is automatic. Nothing is automatic with the VA. Nothing is automatic with regard to discharge upgrades. Now, there's a rumor that has been circulating since at least the Vietnam era that if you get a bad discharge, don't worry about it, it'll just automatically get upgraded in 6 months. I have still heard that from younger veterans. That is absolutely not true. You have to ask for everything that you want changed, and you have to fight hard for it, which is where our pro bono volunteers come in. So it's very interesting to see the differences among the branches of service. You'll see the Army, if you look in that other than honorable column, 3% of soldiers get an other than honorable discharge. When you drop down and look at the Marine Corps, it's triple that, 10% get an other than honorable. So not surprisingly, most of our clients are Navy and Marine Corps veterans. We do see some Air Force cases and some Army cases, of course, but you can see by the numbers who needs the most help in this area. We're not going to get too far into the weeds on this because, like I said, I could do a whole other training on this, and Alexis will hold me to that. There's something called the VA character of discharge. Also very confusing. Veterans who apply for VA benefits are supposed to be routed through this character of discharge to determine if the VA can find them eligible for benefits, even if they have an other than honorable discharge. That doesn't always happen like it should, and often they are denied, even though they should not be. If they are granted VA healthcare and disability benefits, it does not change what's on that DD 214. They still need to go through the Department of Defense discharge upgrade process, which is our focus for today. So these are interesting and difficult cases. Now that I am serving veterans nationwide, it's been really interesting to see the differences among the states. So certain states will allow veterans to have health care and disability benefits with an other than honorable discharge, and certain ones will not. And I just heard recently, I think an organization is going to be filing a class action lawsuit about that because it shouldn't matter where you live. These are federal benefits. But just be aware that veterans with bad discharges oftentimes do not have access to VA healthcare or benefits. There are some statutory bars to benefits, which I don't see too often. There's discharge as a conscientious objector, discharge by general court-martial sentence. We usually see a special court-martial sentence, desertion, discharge because they were absent without leave for 180 continuous days, or resignation by an officer for the good of the service. Those are pretty rare in our office. What we see more often is the regulatory bar to benefits, accepting an other than honorable discharge to escape trial by general court-martial, mutiny or spying, an offense of moral turpitude, which is very much open to interpretation. Willful and persistent misconduct is the one we see cited all the time. So when a veteran applies for VA benefits and they go through that character of discharge process, the VA, if they have any misconduct, which clearly they did to have an other than honorable discharge, the VA will say, oh, there's a regulatory bar, we can't give you any benefits because you committed willful and persistent misconduct. And in the battle days, a regulatory bar that is still on the books is homosexual acts involving aggravated circumstances, which again is very much open to interpretation. Now, the good news is there's a way around that, but veterans don't know that. And there aren't enough advocates who know this and can help them through the process. So there's something called the insanity exception, and that is not the criminal court definition of insanity. I meant to add the definition on here, so I will have to send that as a follow-up. But in general, it says the VA will find that a veteran was insane at the time of discharge if their behavior is so far from their normal behavior. It departs completely from their normal behavior and the expected behavior in their community. So it's a squishy definition. It's a very long and squishy definition, but we can use that to our advantage when we're arguing for veterans. So if the VA finds that the veteran was insane at the time of their discharge, that is going to override the statutory and regulatory bar to benefits, which is huge. So for instance, I have argued that for a veteran who developed bipolar during military service, of course he couldn't conform to military standards with untreated bipolar. Nobody could do that. So just pointing that out to the VA resulted in healthcare and disability benefits for that veteran. You can also use this argument to overcome a finding that the veteran committed willful and persistent misconduct. It could not have been willful misconduct if the veteran was suffering from severe mental health issues. This is just a little overview of the types of discharges based on LGBTQ status. And I do want to thank Bay Area Legal Services. I did a presentation with them a couple of years ago on this topic, so a lot of the information is from them. And for anyone who wants more details on this, feel free to reach out to me. And like I said, I try to do a Don't Ask, Don't Tell focused discharge upgrade training at least once a year. But I'm happy to share the detailed information with you if you have a veteran you want to help through this. And these are cases we accept through our program too. So even if a veteran has an honorable discharge, but it has that stigmatizing narrative reason of homosexual acts or something to that effect, we can help them get that changed. So there's 5 basic ways to ask for a discharge upgrade for veterans who were discharged under Don't Ask, Don't Tell, or the policies prior to Don't Ask, Don't Tell. In the really bad old days. So you can argue that the discharge was only based on LGBTQ status. And of course, with the repeal of Don't Ask, Don't Tell, that is no longer valid. But remember what I said, nothing is automatic. So that worries me because I think there were a lot of veterans discharged under Don't Ask, Don't Tell or previous policies who have no idea they can ask for an upgrade or ask for a change to that narrative reason. And that's really sad. So please help me spread the word that those veterans absolutely have the right to file for an upgrade. And it should be a fairly easy process, but nothing is automatic. So it's important to try to help them through this process because they may have just, checked out of ever being recognized as a veteran for decades. So it's important to help them through that. You can also argue for an upgrade if the discharge is based on Don't Ask, Don't Tell and aggravating factors. Discharges based on substance abuse related to the emotional toll of hiding who your true self is during Don't Ask, Don't Tell, or a pretextual discharge, which is essentially where the service member just is tired of hiding who they are and is tired of being, discriminated against or harassed, and just does anything they can to just get out of service and be done with that. And constructive discharge, also same type of thing. I do want to mention that we help veterans, transgender veterans with name changes. There's no gender listed on the DD-214, but of course, if a veteran has transitioned after they were in the military, that DD-214 is going to have their dead name on it. So of course, they're not going to want to show potential employers or landlords a document that has a different name on it because that will lead to a lot of questions. So we can definitely help with that. There's some magic language to include in these discharges, which we'll get to in the next slide. When Don't Ask, Don't Tell was repealed, the Department of Defense told the boards that they should normally grant requests for upgrades when there were no aggravating factors like sexual assault or something like that involved in the discharge. So it's supposed to be fairly streamlined and simple, but again, this process is emotionally difficult for veterans, whether they're LGBTQ veterans or just veterans who have a bad discharge. No one expects their military career to end like that. So it's really helpful to have an advocate help them through this process. It is a long process, even when it's supposed to be simple and streamlined, and just helping them stay on track and make sure they, fill out all the forms correctly. That'll lead to a much better outcome than them trying to get through this by themselves while being really upset, remembering what happened. I won't go too deep into the sample language, but basically we want to be sure to ask the boards not to include anything on the upgraded DD-214 that references the fact that the person was discharged under Don't Ask, Don't Tell, or that the person is a transgender veteran, because that would be really stigmatizing. So again, nothing is automatic, and you have to ask for every little thing that you want changed on the DD-214, or it will not get changed. And this is same language for the upper level review board. And that's thanks to Swords to Plowshares. They put all this together. Great organization out in San Francisco. So if you're in that area, make sure to reach out to volunteer. This is some sample language if there were aggravating factors. And some of you may know that during Don't Ask, Don't Tell and before Don't Ask, Don't Tell, there were whole units investigating service members to see if they might be gay and they might be committing misconduct. So it's not surprising if a veteran discharged in those circumstances, they would have found some sort of aggravating misconduct to discharge them under. In my other presentation, I have more details about how to apply for a name change for transgender veterans under each different branch of service. So again, reach out to me if you need those materials, but I just pieced it together from different things I found online, because as of last year, I believe, or the year before, there is again supposed to be a more streamlined, efficient process. They're not supposed to be routed through the usual 2 to 3 year long discharge upgrade board decision process. They're supposed to be routed to a separate lane when we're just asking for a name change. We're not asking for anything else. The veteran already has an honorable discharge. The narrative reason is fine. We are just asking to make sure their name matches their current identity, their current documents. So you just have to submit evidence of a legal name change, which would be a court-ordered name change. And that is literally it with the one-page form to apply to the boards. So some of the boards want you to do it online, some by paper. I just test drove this process this summer for a veteran, and I'm happy to say that it took only 5 months, so much faster than the usual decisions. And she did receive her brand new shiny DD-214 and got it framed and sent me a picture of it. So she's thrilled to have all her documents matching after all these years. So please spread the word about that. That is something a veteran could do on their own if they feel up to it. But if not, they can reach out to us. We're happy to help with that. Okay, so the bulk of our work is focused on mental health conditions and arguing that those mitigate any sort of misconduct that led to a bad discharge. So that's what we will get into. So for those of you who are new to this area of practice or new to legal aid, this is just a neat graphic that describes trauma and post-traumatic stress disorder. So trauma stands for traumatic event, re-experiencing that event, avoiding memories of that event, being unable to function. It lasts for at least a month, and it can cause arousal, meaning that you're really looking around at everything and just really jumpy, basically. But remember, trauma is not just something that is experienced by veterans. A lot of our clients and a lot of our coworkers have experienced trauma, unfortunately. So it is a normal response to abnormal circumstances. So if you don't remember anything else, remember nothing is automatic and that PTSD is a normal response to abnormal circumstances. Most of us will never experience what veterans have experienced during combat. But that's not to say that other people don't have PTSD. So it is not specific to veterans. It doesn't mean there's anything wrong with someone or that they're weaker than some other veteran who doesn't experience PTSD. It is a normal response. These are the clinical requirements under the new DSM-5 psychology manual. You have to be exposed to trauma. You have to re-experience the event either through dreams or flashbacks. And you don't have to meet all these requirements, but most of them. And you try to avoid memories of the event or try to avoid things that remind you of your trauma. Like anyone who served in the desert may not go to the beach because they don't like the feeling of sand. That brings back bad thoughts. And it can't be something temporary that lasts for less than 1 month. It has to last for at least a month. Now, the veterans I have worked with over my career, it's really sad to see how long this lasts. This is a lifetime trauma for most of them. Even Vietnam veterans will still wake up, dreaming that they're in the jungle, that they're covered in blood. It's really sad to see. So I'm going to put some resources at the end of this PowerPoint for those veterans who are locked out of VA healthcare for whatever reason. I highly recommend vet centers for combat veterans. They offer free counseling. That can also help our clients through this process as they go through the discharge upgrade process with us, because it is going to bring up all these memories when they go through this process. And like I said, there's many different ways to experience trauma. It could be from combat, it could be from military sexual trauma, domestic violence. First responders can experience it. We see a lot of childhood trauma in veterans records. And unfortunately, the rates of childhood trauma and sexual assault in the civilian world are terrible too. So it's definitely not just a military problem. Traumatic brain injury overlaps with PTSD in some ways. And it's been called the signature wound of Iraq and Afghanistan veterans just because of the prevalence of improvised explosive devices or IEDs on the sides of roads. That's also why some of those veterans have a really hard time of following civilian traffic laws, because they're being triggered by, bags of trash on the side of the road, or, someone coming towards them suddenly. And they may drive really fast and aggressively because that is what they are trained to do in the combat zone, and that was the only way to survive. There's still a lot we don't know about traumatic brain injury. The brain is still so mysterious and it affects everyone in different ways. You could have a mild, moderate, or severe traumatic brain injury, and then we're going to get into what kind of symptoms that causes. So these are some of the side effects that can come from a TBI. And like I said, they often overlap with PTSD symptoms. So the veteran may have difficulty thinking clearly, concentrating, remembering new information. So that's important to be mindful of when we're representing veterans. Try not to be impatient with them if they can't remember the details of everything. That's also quite common with PTSD. It's like a protective thing that our brain does and doesn't let us remember all the details very clearly of a trauma. So these overlapping things can make it a little difficult to put a case together. So just be extra patient and understanding that, the veteran is not trying to make your life difficult as an attorney. It's just they may have some cognitive limitations due to TBI and PTSD. If you're giving them a bunch of homework to do, that's what I call it when I have a list of documents I need them to gather for an upgrade. I make sure to email it to them, because I think of it as like when I go to the doctor, I forget everything that's been bothering me for the past year if I don't write it down, because I'm stressed to be there. And I know it's the same when they're meeting with us. They're stressed to be meeting with a lawyer. They're stressed to be talking about what happened during their military service that led to a bad discharge. So just take those extra little steps that can really help move the case along. As far as physical effects, they could be experiencing headaches, nausea or vomiting, balance problems, dizziness, feeling tired, being sensitive to noise or light. So of course, this makes it difficult to work. And then emotionally, they can be irritable, sad, nervous, or anxious. Again, a lot of those overlap with PTSD symptoms. And sleep disturbance. This is really, really common among veterans. They will sometimes be on a lot of medications for sleeping or to decrease their anxiety, but then those just make them feel like zombies, so they quit taking all of them. So it's really tough to treat. There's no one size fits all treatment. And of course, that affects how they can function and remember things also. All right, so now we're getting into the nitty-gritty a little bit more of how you apply for a discharge upgrade. And Alexis, I'm counting on you to let me know if there's anything important in the chat, because if I press it, I'll probably do something wrong here. So gonna keep going along.
No
Hopefully
problem.
these are just questions.
Yeah, there's just questions here.
Perfect. So discharge review boards. It's a totally separate process from anything VA related. So that's also a very common misunderstanding. Veterans will think if they applied for VA benefits, that they also applied for a discharge upgrade. That is not the case. Totally separate processes, totally different agencies that you're applying to. So the lower level discharge review board, which I'll refer to as DRB, because we have lots of acronyms in veterans world. So lots and lots of acronyms to learn. I did a lot of Googling when I first started this work. So they have the authority to upgrade the discharge and change the narrative reason. But again, you have to ask for each thing. It's not, if they upgrade the discharge, they're not automatically going to put a nice narrative reason. You could end up with an upgraded discharge and a really stigmatizing narrative reason still on your DD 214. So again, nothing is automatic. Ask for everything you want, or you shall not receive it. They can also review punitive discharges, which was like the bad conduct side of that chart I showed you, from a special court martial, and upgrade based on a clemency argument. So you're basically asking the board to take mercy on you. They do not have the authority to grant an upgrade from a general court martial or grant medical retirement. That's only the higher level Board of Corrections. Believe it or not, there is a one-page form to file for all this complicated stuff I've started telling you about. So that's a big takeaway from this. Please tell veterans not to just file a one-page form, unless it's a relatively simple transgender name change. Otherwise, I just don't see how that's going to be granted. And that's probably why the upgrade rates are so low overall, even with all the good things that have happened in the past 10 years of my practice, which we'll get into, all the helpful guidance memos. I don't think you can tell a veteran story on a one-page form, which is where our pro bono volunteers come in. We mentor them and help them put together a really comprehensive case for veterans, because that's what it takes. And they don't have unlimited tries at this. So it's really important to try to get it right the first time. Now, chances are by the time they come to us, they may have tried and failed to get an upgrade several times on their own. So we'll get into how to deal with that. At the lower level DRB, the veterans only have 15 years from the date they were discharged to file that DD 293 application. Now, if it's been more than 15 years, don't worry. They can just apply to the higher level board. So I don't want you to think that there's no hope after 15 years. But for this first level review board, you have to do it within 15 years. There are no exceptions. I was hoping for some exceptions when some of those helpful guidance memos came out, but no, there are no exceptions. So the board is typically comprised of 5 officers. So these are military officers. During COVID, it's been 3 officers. So there's already that tension. Most of our clients were enlisted service members. So the officer experience is very different from the enlisted experience. So there's already that gap that we want to try to overcome and tell the veteran's story and explain why things went wrong and how to mitigate that through an upgrade. This level board offers a records review, meaning everything you submit is on paper, or you can ask for a personal appearance hearing, which has been virtual lately, either by telephone, which is what the board prefers, or video. Now, the important thing to know is that if the veteran is still within that 15 years of discharge, they can ask for a records review first. And if that doesn't work to get what they've asked for, they can go back within that 15 years and file another application asking for a personal appearance hearing. However, they cannot do the reverse. If they ask for a hearing first, they're done at the board at this level, and they would then have to appeal to the Board of Corrections. So we usually recommend doing a records review first if the veteran has enough time within that 15 years. Why not try to get an upgrade easiest way possible for the veteran? The personal appearance hearing can be really stressful. Some veterans really want to have a personal appearance hearing, but in my experience, most of them are a little bit terrified to go in front of a board of officers and explain what they did wrong and why the board should take mercy on them. So if we can put together a really good package on paper, let's try and get them what we're asking for the easy way. And the standard of review for the DRB is the board will assume the discharge was proper unless the veteran rebuts the presumption of regularity with substantial credible evidence. So the burden of proof is completely on the veteran to show what the military did wrong. And this board is going to presume the military did everything right in kicking them out with a bad discharge. So that's a big hill to climb. And that's where advocates come in and can really make all the difference in the world. The magic legal terms at the DRB are that the discharge was improper or inequitable. The higher level Board of Corrections and Military Records, so we'll call that BCMR as our acronym for this slide. This is the higher level board. Again, it's a 1-page form, the DD 149. They have a box to check if you want a personal hearing, but rest assured you are not getting a personal hearing. So if the veteran wants a personal hearing, they've really got to do that within those first 15 years at the DRB. They grant personal hearings once every few years. So you can check the box all you want, but it's probably not going to happen. So they have a little bit more power than the DRB to change different discharges or grant medical retirement. They can change reenlistment codes now. I think the DRB, the lower level, technically can't change reenlistment codes, but they have before when I've asked them. So it never hurts to ask, because you'll want to ask for an upgrade to the character of service to general or honorable, ask for a change to that narrative reason, also ask for a change to the reenlistment code, because if they're showing that DD 214 to someone who's been in the military or knows the military, and it says RE4, that means we don't want you back. So even if they had an honorable discharge, if it got upgraded and a good narrative reason, that RE4 is going to be a red flag to potential employers or like veterans organizations that they want to join. So I just believe in asking for everything, and they will usually give it to me, but you do have to ask for it. And the BCMR can review all punitive discharges and upgrade on the basis of clemency. They can't set aside a court-martial conviction, but they can still upgrade the discharge that resulted from that. So say it was a bad conduct discharge as a result of a court-martial conviction. They can't set aside the conviction, but they can upgrade that bad conduct discharge to honorable or general or other than honorable. Again, a one-page form. I never recommend filling out the one-page form. You do have to fill out the form, but you want to include a lot of evidence in addition to that form. Now, the nice thing about the BCMR is that there is technically a 3-year deadline from the discovery of the date of the injustice. Well, that's kind of a squishy term, right? So we can be creative with that. And the board, in my experience, has always waived that 3-year deadline. But again, you have to ask for it. It's not automatic. So for our Vietnam veterans who have maybe been denied, 10 or 20 times, they've been fighting this longer than I've been alive, they can still apply to the Board of Corrections. We're going to need some new evidence, which we'll get into later, but you can just ask for a waiver of that 3-year deadline and say the veteran didn't have access to legal services, or you could blame COVID. I blame COVID for a lot of things now. So why not put that in there as a way to get the deadline waived? But they are very fair about waiving that deadline. You just do have to ask for it. This board is comprised of 3 civilians, but generally like military related civilians. So they might work for the Department of Defense in a civilian capacity. The majority vote prevails. Again, really hard to get a discharge upgrade. By the time you get to the BCMR, there might be all sorts of negative evidence in your file that has been developed during the past applications. So it's really important to help veterans gather up strong medical evidence of their mental health conditions, cite these memos that I'll talk to you about in a few minutes to try to overcome that burden of proof. So the BCMR, again, just like the DRB, will assume the discharge was proper unless the veteran rebuts the presumption of regularity. And the magic legal terms for this board are error and injustice. Typically, we're arguing injustice. It's not too often we find a legal error, but it's always important to look for them. But we're basically arguing it was an injustice that the veteran received such a harsh discharge for misconduct that was related to PTSD or military sexual trauma, etc. Reconsideration. So like I said, there's not technically unlimited chances for discharge upgrades, which is why it's so important to have an advocate's help to put together a good package, because you don't have unlimited chances. However, you can always submit new and material evidence that was not previously considered. I have done that before. I've done a reconsideration of reconsideration of reconsideration. Some of you might know my motto is keep going until they agree with me. So I will do whatever I can. If I think that veteran has a good case, we will just keep going until they agree with us. Again, these are the terms of art for the DRB and the BCMR, and propriety and error. That's basically finding a legal error. My favorite one is the limited use violation, which mostly only applies to the Army. And that is when a soldier self-enrolls in substance abuse treatment, that the records from that treatment or drug tests during that treatment cannot then be used against them in an administrative or punitive discharge. So I have one of those. That was my very first discharge upgrade case. I could not believe it really worked. If the Army violates that limited use policy, they have to give the veteran an honorable discharge. And that is what happened. We had an other than honorable, and I filed this and we waited a long time, probably 2 years, and it came back honorable. So it really does work. I look for that all the time now. Just because that was my first case. And then you can also argue a retroactive change in policy. So that could be don't ask, don't tell. That's not in effect anymore. So any discharge that happened during don't ask, don't tell should be overturned based on the new repeal of that. But again, you have to ask for it. Nothing is automatic. I wish it was automatic. It'd be so much easier. So, like I said, our most common arguments are inequity at the DRB and injustice at the BCMR. That is arguing that current policies are different. So there's a new Navy policy that says the Navy is supposed to carefully screen sailors and Marines who have signs of mental health symptoms. So what I like to do is attach that policy and say, well, if this veteran had been discharged today, there's no way this would have happened. So it was just an injustice that they got such a harsh discharge with no mental health screening. You can also argue, can go through the regulations in effect at the time that the veteran was discharged and argue that their discharge was inconsistent with disciplinary standards at the time. So if the regulations state that the veteran was supposed to be given a general discharge for a certain type of misconduct, but they got another than honorable, you can make that argument. You can also insert some arguments about racial discrimination or gender discrimination, overall command culture. You can get pretty creative with these cases, which I enjoy. It's definitely telling the veteran's story to the board and humanizing that veteran's experience and explaining to the board why they should upgrade this veteran's discharge. And I don't usually recommend just making one argument unless it's that limited use violation I just talked about. Other than that, I think of as many as I can and see which one will stick. Maybe they don't like my first 3 arguments, but they like the 4th one. So it's important to include everything to give them the best chance at an upgrade. And you can also argue for those veterans who served a long time or who had a combat tour or several combat tours, including combat awards, excellent evaluations, until the mental health symptoms set in or until they were victims of military sexual trauma. It's sometimes helpful to show that timeline, that behavior and performance was excellent, and then there was a stressor, and then it went downhill fast, leading to their discharge. But again, you can get creative. You can ask for letters of support from people they served with. Those can be really powerful to make a difference to the board and show that the board should not judge the veteran by their one instance of misconduct, but instead refer to all these letters of support from people that served with this veteran in combat and would serve with them again. Those letters can be really, really powerful. Again, the standard of proof is preponderance of the evidence. And under the new Hagel, Kurta, and Wilkie memos, which we'll get into, the board is supposed to give liberal consideration to mental health arguments. That doesn't mean it's going to be easy or that anything is automatic. So reconsideration again, you can ask for a personal hearing if you ask for a records review first. You can cite new discharge policies. You can cite policies that are materially different that were in existence at the time of the discharge. The big one I use is the veteran was not previously represented by counsel, because most veterans can't find an attorney to help them with this process. There just aren't that many out there. And the service officers at the county service offices or other organizations, they do a lot of great work, but they don't really have time to put together a huge discharge upgrade case. They have veterans coming in all day, every day, streaming in the door for all different types of veterans benefits applications and survivors benefits. So it really does help to have an attorney dedicated to that to help these veterans. And again, you can always have new and relevant evidence. That could be a personal statement, it could be a new buddy statement, it could be a new policy that's come out from the military. Be creative with it. Anything you can do to reopen and give them another chance. I haven't done an appeal to federal court for discharge upgrade yet, so we won't go into huge details about that, but in order to appeal, this would be a Board of Corrections decision. So you've gone through all the levels of discharge review boards and been denied. You can appeal to federal court, and the court must hold unlawful and set aside agency action if it is arbitrary, capricious, and abuse of discretion or otherwise not in accordance with law. So that's a pretty high standard, but that is an available avenue. I always hope we'll win before we get to that point. That's my goal. This is just a helpful chart to compare the discharge review board to the Board of Corrections. The different names for the forms, the time limits, the makeup of the board, the magic words. So it's a handy reference just to keep around to make sure you use the right words in your brief. Okay, so I think this is a good spot to take a little break. I figure we can break till about 1:01. That way everyone can go stretch. If anyone fell asleep, wake them up.
I doubt that anyone fell asleep. Actually, there's lots of questions in the chat, and I always love that about the folks that do this work. Always participating and learning. So everyone take a break. You said come back 1:01.
1:01.
All right, perfect. See you all in just a bit. Stay tuned.
Yeah. Welcome back, everyone. Thank you for sticking with us. I love to see all the good questions in the chat, and thank you to our attendees who have been answering some of the questions for me. I appreciate that. I'm going to do my best to save plenty of time at the end to answer questions, and also be thinking if there's other topics you'd like me to talk about later in the year. Like I said, I try to do a discharge, don't ask, don't tell focused training at least once a year, but if there's other topics you're interested in, let me know. And let Alexis know. All right, so pre-brief preparation. We already talked about the application forms. Again, I never recommend just submitting a one-page form. And remember, you have to ask for everything that you want changed. Otherwise, it will not be given to the veteran. A detailed brief is important. Now, it depends on your personal style. There's no set format that's required by the boards. The boards may have a JAG or two attorney on them, or they may all be non-lawyers. Depends on the luck of the draw. So you have to remember to write to your audience. What I'm always keeping in mind with these cases is there are a ton of cases coming through these boards every year. I want to grab their attention. I want to control the narrative and really put forward a strong argument for that veteran. And that's where the brief comes in. It could be a short brief, it could be a 20-page brief, it depends on your personal preference. I recommend keeping it as short and sweet as possible while still getting your point across. You don't want to bury the lead in a bunch of extra pages because you don't want to lose their attention. I would say you only have one chance, but as I said, there's lots of reconsiderations, but you hope to never make a veteran go through that many reconsiderations because each one takes several years. And for veterans who are locked out of VA healthcare and benefits, that is a really long time to wait. So we also have our volunteer attorneys put together exhibits. Those can be a personal statement from the veteran, medical evidence, medical research that's new and you want the board to know about, buddy statements, some military records. Now the boards will generally have the veterans' personnel records, but they're not typically going to develop other evidence. They're not going to give you any evidence to help you out for sure. Now, some of the boards will request the veterans' VA records. I'm not really sure how they get permission to do that, but sometimes they do. So just be aware of that. Now, when you're putting together the package, we don't recommend submitting 3,000 pages of VA records because then you're just going to annoy the board. And we're trying to keep them on our good side and get them to say yes. So I only submit the records that I am citing to in the brief, just bits and pieces. You can also include post-service medical records, whether those are from the VA or a private healthcare provider, but be aware you don't have to. If those records are not helpful or not relevant, you don't have to submit them. And you can be creative. You can submit other evidence of good character. So you could ask the veteran to get an FBI background check. If one of your arguments is that the veteran has been an absolute law-abiding citizen since their discharge, no problems with the law, no drug use, develop evidence in that regard. If the veteran had a substance abuse problem during service, you can show evidence that they completed a substance abuse treatment program and have been clean and sober. So really, you can get creative telling this veteran's story. Now, these are all the steps to submission, but if you are a pro bono volunteer with the Veterans Consortium, we do a lot of these steps for you. So we do the initial client intake to make sure they meet our program requirements. There are no income guidelines, but there are those guidelines that they have to have a mental health diagnosis or symptoms. There's just certain criteria they have to meet. So we'll go through that screening and then we'll request their records, their military records from the National Personnel Records Center. A note on that, it takes a long time and they were closed for a long time during COVID. So that really slowed down our cases. And I hate to see that because, like I said, it takes a long time to get a decision from the board. So I really want to try to keep them moving while they're with us and get them submitted. And then we can hurry up and wait. So there are some other ways to request records, and we try to have veterans request their own records because it's just so much faster. If they can access them online, through e-benefits or through My Healthy Vet, that can really speed up the process. Once we get all the records that we need, then myself or my staff attorney will review all the records, and it's usually thousands of pages. And we're looking for positive aspects. So, was there misconduct before their combat tour? If so, that might make it more difficult to argue for an upgrade. But if we see that that veteran had excellent evaluations, perfect conduct, lots of awards, and then suddenly everything took a nosedive, that can be a really helpful timeline to show the board, to show that that was not their normal behavior and it was due to the stressor, whether it be combat, sexual trauma, racial discrimination, etc. So we do the first 3 steps for you. And then we put a timeline together and combine the records and assign them to a volunteer attorney, which we hope some of you will become volunteer attorneys after this training. And then it's up to you to talk to the client, fill in any gaps that you see in the evidence. You know, as you're starting to think about putting together the brief, what other information do you need from the veteran? And just develop a good relationship with the client. And everyone's different. Some clients want to hear from you a lot. Some clients just want to send whatever evidence they need to send you, and they don't want to think about it too much because it's really stressful. So you'll just have to see how your client reacts to the process. But once they make it to this point in our process, they're usually ready to move forward. Now, some veterans wait a long time to ever apply for an upgrade because it is so stressful. And they're intimidated by the paperwork and going before the board and all that. So most veterans are just really happy to know that they have an advocate on their side to get them through this really long and painful process. And they're happy just to have someone to listen to them, because chances are they've been told no a lot. They've been turned away from the VA possibly. They've been told they're not veterans. So just having someone to listen to them and be on their side is really powerful, no matter what happens at the end. You may decide you want to gather additional evidence. Usually the more the merrier, especially when you're making equity arguments. The personal statement is really important because that's the veteran's chance to tell the board what went wrong and why they deserve an upgrade. Now, with that being said, it's a really crucial piece of evidence, but it is the hardest one for veterans to put together. I have a case I'm waiting on right now where everything's ready to go, except that personal statement. It's really, really hard for them to sit down and write it. So if they have a counselor or a psychologist at the VA or elsewhere that they can sit down with or meet with after they're working on writing this personal statement, that can really help, because we are counselors at law, but we are not that type of counselor. And it can be really stressful and bring up a lot of bad memories when they sit down to write these statements. Now, sometimes in the records, the veterans will have already applied for VA benefits and there will be some type of personal statement in there. So sometimes you can rework that into a personal statement for the upgrade. So I recycle and reuse when I can. I don't have a veteran tell me details about their trauma unless I need them, because I am not a psychologist or psychiatrist. I don't need to re-traumatize them when the information is all there in the records. It's just if you need some clarification about something that you may need to ask. But again, remembering back to the PTSD and TBI slides, they may not remember any more details than are already in the case. Buddy statements, like I said before, can be really, really powerful. Those have made the difference in me deciding whether I'm taking a case or not. Some cases I'm kind of on the fence about, it's not super great evidence. And then those buddy statements come in and some of them make me cry. I'm like, okay. All right, we're going to go forward with this and we're going to show the board that this veteran is much more than that one instance of misconduct. You can even bring in post-military accomplishments. So say the veteran has raised a family or been successfully employed or is helping other veterans. I've talked to so many veterans who, in spite of having bad discharges and not getting any benefits, are trying to help other veterans in whatever way they can. So that can be really helpful evidence. Again, you are telling the story with your brief. You are not trying to bore the board to death. So really tell the story, be creative. I always tell my volunteers, control the narrative. If we are working with a veteran who is a combat veteran, has great medical evidence showing PTSD, combat awards, we are going to ask for an upgrade to honorable. If they have an other than honorable, we're going all the way for honorable if there's good evidence there. We're not even going to mention general. The board could, make a compromise and say, we're not going to give you honorable, we'll give you general. But I am not planting that idea in their heads. So when I have a story I want to tell for this veteran and I have a goal in mind for the board to agree with me about, I'm sticking with that. So it really is about being creative and controlling that narrative and helping the board see that your veteran is human. Yes, they made a mistake. Here is why their mental health mitigates that mistake. And here is how you can fix this injustice by changing their discharge, their narrative reason, their reentry code, their separation code, everything. And then of course, at the end, we do have to fill out that one-page form, but that should be the last step. And it is just a formality, but you want to have a whole powerful memo or brief and evidence to submit. Again, not thousands of pages, but you do want to have evidence to back up your story that you're telling to the board. We've talked a little bit about this throughout the presentation, but it's really important to build trust with the client. Like I said, typically these veterans have not had the best experience as civilians because of that stigmatizing discharge that they carry around. They probably don't interact with veterans organizations much. They may have been told no by the VA several times. So it's just important to let them know you're on their side. You can't guarantee any outcomes, but you're going to help them through this process. Learn the lingo. So yeah, there's a lot of acronyms and other military lingo. I forgot to say at the beginning that I am not a veteran myself. I don't come from a military family, so this was all new to me. I got into this completely by accident when I worked at Community Legal Services. So I am forever grateful to Community Legal Services for putting me on this path, but it was a complete accident, one of the happiest accidents of my life, because I ended up absolutely loving working with veterans and doing disability benefits and upgrades. But this was all new to me. I didn't know any of the lingo. There was a lot of Googling involved. And I relied heavily on Swords to Plowshares and Connecticut Veterans Legal Center for their sample memos and just hints and tips. And then there's all sorts of great trainings out there. So for those of you who are interested in VA benefits and discharge upgrades and everything in between, there's a great training every year put on by PLI. And if you work for legal aid, you should have a free privilege membership from PLI. That allows you to attend this, I believe it's a 7-hour training put on by Swords to Plowshares, Connecticut Veterans Legal Center, and a couple others. And they go through all the different possible ways to help veterans as a legal aid attorney or a volunteer. So highly recommend that. That was in November. It's in November every year. So definitely look that up. I'll try to put the link in my materials at the end too. Some veterans are not going to feel comfortable telling you their life story in the first meeting, or maybe not ever, but you can work on it. So I just caution you not to be too impatient. Don't try to get all the information you need in one meeting because it is really stressful for them. You want to build that trust first and build rapport, and then get into some of the details if you need to. Again, if everything you need is in the records, if there's a statement about the military sexual trauma, if there's a doctor's opinion about it, I don't need to know the details of it any more than what is in the records. Learn the client's motive. This is really important. Some advocates in this area usually believe in asking for an upgrade from an other than honorable to a general, so they don't ask for honorable. If your client's sole motivation for getting an upgrade is to go back to school with their GI Bill education benefits, that's not going to happen if you only bump them up to a general. So if they have strong enough evidence, you're going to want to ask for an honorable. Like I said, the board can do whatever it wants, but if that's your client's goal, you need to try to make that happen for the veteran. A lot of veterans, now I'm seeing this nationwide, some veterans with other than honorable already have VA healthcare. They may already have 100% VA disability rating. So nothing I do is going to give them more benefits. It's more a recognition of their service and being recognized as a veteran. So that might be their only motive. You know, they may be too old to go back to school or not want to go back to school. They already have benefits. It's about changing what's on that DD 214 so they can proudly show it to people. So their family can get a flag when they're buried and get veterans, you know, military honors at the funeral. There's a lot of different motivations for this. So I have some clients who have unfortunately passed away either before or after we started this process. And so it's important to talk to the family, but mostly they want to continue on with the case for the veteran because the veteran knew at the time that they passed away that we were fighting for them for this upgrade. And we're hoping it turns out well for them, even though they're not here to enjoy it, but their family can have that, you know, for posterity. Again, it's a very emotional process for veterans, some of them. I would say especially the older veterans, but it's also true with the younger veterans. Just feeling like they're not a real veteran, even if they served 3 combat tours and they ended up with a bad discharge. There's a lot of stigma that goes into that. They will either be told by other people or tell themselves that they don't deserve anything from the VA, and they just may feel like complete outsiders in this process. Make sure you keep in touch with the client. So these cases take forever, but just reach out once in a while and make sure they're okay. See if they've heard anything from the board. That happens sometimes. The board will tell the veteran, you know, that they made a decision and they forget to send me a copy. So make sure you let the veteran know that you're around. Let them know to let you know if they hear anything from the board, because it may be something you need to rebut. If it's a medical opinion from the board, that's really important. And you just want to know what happens when the decision comes out. And you want to know if your veteran has moved. I mean, these cases can take several years, so they may have moved several times. And you want to make sure you know that so you can get in touch with them when hopefully the win comes in. Don't want any delay on that, telling them the good news. So I'll go through this briefly, but like I said, if you're a volunteer with us, we do this part for you. There's a form called the SF-180, and that's how veterans can request their military records. Sometimes it will come back and say, who are you? Did you serve in the military? We don't have any records. That is not fun. So sometimes you just have to keep requesting, and sometimes they will magically find some more records. Or the veteran, I love it when veterans have their own records. If they knew to ask for it when they were being discharged, that makes your life so much easier, because then you have a place to start while you're waiting on gathering all that other evidence like personal statements and buddy statements. You can also request court-martial records or criminal investigative reports that may be in there. Now, it's even helpful if nothing comes back on that. Like, say there's some reference in the veteran's case to some misconduct that the criminal investigative division investigated. Well, you want to see those, right? So you request it with FOIA or any other way you can think of, and it'll come back and say, we don't have any records. Okay, well, I can submit that to rebut the presumption of regularity and say, okay, you can't use this against the veteran when there's no records there. So use it in your favor if you can. It's amazing that even some of the younger veterans, there will be records missing when we request them. So again, use that argument in your favor. Say, okay, I mean, you say this and this happened, but you don't have any records of it. So let's decide to upgrade this based on equity. And you can, like I said, request post-service records. It's easiest if they have VA records because they should be able to access that through My Health You Vet online and just email you the records, and even email you just the mental health records if that's what's important. It's a little harder if they have civilian providers. It's usually easiest for them to go to that provider or request it from them and then get it to us rather than going back and forth with permission forms. Now, unfortunately, a lot of veterans with bad discharges just don't have any service records because they haven't had any health care since they got discharged. So don't hold that against them. You know, if they have been told by the VA they're not allowed to be seen there, there's not much they can do. And in states without Medicaid expansion, they probably just don't have any health care. So again, I recommend the Vet Center for combat veterans or military sexual trauma survivors. Those counseling records, while they're not records from a doctor, they can be helpful just to show the veteran is seeking treatment. A lot of evidence gathering goes into this work. So there is no nice record already put together for you. It's all about developing it. And like I said, we try to do as much as we can before we get these two volunteer attorneys, but things will come up. You know, the veteran will say, oh, you know what, I could ask this buddy I served with in Iraq to write me a personal buddy statement. And that's the beauty of the internet. You can find people and see if they'll help you out. And usually they say yes. And the more the merrier with the buddy statements. I've submitted 6 or 7 before for veterans. They can just be such a powerful glimpse into the veteran's behavior under conditions of combat. Now, I don't focus typically on the pre-service evidence. I start their life when they enlisted in the military. Everyone's different. Everyone has a different way of doing this. That's my way of doing it. The only time I bring up pre-military life is if there's a nice compelling reason that they enlisted. So say their entire family has enlisted in the Marine Corps, and of course they wanted to follow that family tradition. I'm putting that at the top. That will grab the board's attention. It helps turn this bunch of paperwork into a person to the board. Or they may have enlisted after 9/11. You know, that's what I put in. I don't really focus on pre-military trauma. A lot of veterans, unfortunately, have had really tough childhoods. I don't really bring that up because what I'm arguing is that what happened in the military either caused their mental health issues or exacerbated something. And that's what we're arguing about. So again, it's controlling the narrative. And that's your choice, whether you want to bring up childhood, but I think I'm a little paranoid about that from having done VA disability work for so long. The VA will try to blame childhood trauma for everything that a veteran is experiencing at the age of 40. So I'm very cautious about submitting anything to them that I don't have to. Sometimes their VA records will reference childhood trauma. It's fine, there's nothing you can do about that. But again, I want to control the narrative and have them focus on this veteran served 3 combat tours, or this veteran experienced military sexual trauma, or all of the above. That's what I want them to focus on. And it is true, I've seen some research out there where someone who experienced childhood trauma is more likely to experience PTSD after combat or some other stressor in the military. There's some evidence of that. But again, when the military accepts someone, they are accepting them as whole and fit for service, no matter what happened in childhood. So I figure if that is the case, we are starting history from when they enlisted, because that's enough to argue about for these cases. Again, pick and choose the personnel and medical records you want to submit. do not submit 5,000 pages of records because those VA records get really long and no one has time for that at the board. They have about 3 minutes per case when the board actually meets. Now, before that happens, there's going to be people looking at the case and making a recommendation to the actual members of the board. But when it comes down to it and they are all in a room together meeting about this case, they only have a few minutes. So you've got to keep their attention and don't, like I said, don't water it down by submitting 20 pages if you don't need to. Just get it out short and sweet, to the point, make it easy for them to say yes. Always try to think from their perspective. They're seeing thousands of these cases. They're assuming the military did everything right. What can you say as an advocate to grab their attention and make them change their minds? I also have had veterans pull up their Social Security earnings record, not because I'm nosy, I promise, but because that shows that they've been employed. So even if they got a bad discharge, they don't have health care, they don't have benefits, they have severe mental health problems, they are still out there trying to work every day. They may have gone through 20 jobs in 20 years, but they're out there trying to work. They have not been arrested. Some veterans have been arrested after service, and you can try to mitigate that, but sometimes it'll be so severe that you just can't argue an upgrade, based on certain arguments if there's a long criminal history, especially if the veteran used drugs during service and that's why they got discharged, and there's no stressor that you can find, and there's post-service drug use and arrests. That's not going to go well with the board. That's the type of case we're going to unfortunately have to say no to and send them materials to try to do it on their own or with a service officer. But when you're a volunteer with us, we will have weeded through those cases already. It's also important to highlight awards. Now, there are some what I call like I showed up to work today awards in the military records. Those you don't necessarily need to highlight. It's the ones like the Combat Action Ribbon, a Purple Heart for being wounded in combat. Those you want to really point out and say, okay, this veteran served 10 years. They were deployed several times to combat zones. They have all these combat awards. All that should overcome one instance of misconduct. Personal statement, I already talked about this. This is the chance for the veteran to tell their story, but it's often hard. They might want you to just listen to them, talk about what they want to say to the board, and type it up. It should still be in the veteran's voice, so I like more of an informal letter layout for these personal statements. Some of them will be fine with sitting down and writing it on their own, but some should sit down with their counselor and do it because it's really stressful. It's important for the veteran to take ownership of misconduct. Say if there was drug use, they should admit they know there is zero tolerance for drug use in the military. They know it was wrong, but they were suffering from really severe PTSD, and that led to a bad choice. And then, that's what your brief is about, trying to explain why all their good conduct and their mental health mitigates that. It's usually one instance of misconduct. Sometimes there's more than one instance of misconduct. And then, of course, support the story with evidence. So make sure the personal statement is lining up with all the other evidence you're submitting as exhibits. And just, check with the veteran if there's any discrepancies. But the personal statement, again, doesn't need to be super long. It can be a page or two, just really heartfelt from the veteran, what went wrong and why they're sorry about it, and why they hope the board will take mercy on them and give them an upgrade. Mental health arguments before the board. These are the wonderful things that have happened just in the decade I've been practicing in this area of law. In 2014, the Hagel memo came out, and that was in response to Vietnam veterans, filing a lawsuit and saying, these boards are just not even taking into consideration the fact that we have PTSD. They're just saying, oh, well, you got a bad discharge, I'm sure you deserved it. So that made a huge difference when that came out. Now, the wild thing to remember when you're representing Vietnam veterans is that PTSD was not even a diagnosis until 1980. So just always keep that in mind. No one knew what to even call this until long after the Vietnam War had ended. We still, I don't think, have a great understanding of PTSD. We made progress. We're still not there yet, but for those veterans, of course, there's not going to be evidence they had PTSD while they were in the military. It did not exist as a diagnosis. So you may have to point that out because they may have been denied on that basis in the past. In 2016, the Carson memo came out, building on the Hagel memo. In 2017, the Curta memo came out. Again, like in case the boards didn't quite understand the first two, this laid it out in even more detail. It focused more on military sexual trauma and the fact that there's often no evidence of that in service. The service member may not have reported it. It may not have made it into the records anywhere. So you may have to look for markers of military sexual trauma, which we will point out when we do our records review and send you a timeline as a volunteer. But there's things you can look for, that don't involve an official report, because often there's not one. You may just have to see that, the veteran went to the clinic a lot after she said she was sexually assaulted. There's a lot of clinic visits, whereas there weren't beforehand. Or there's STD tests, pregnancies, anything out of the ordinary, just changes in behavior. So that was really emphasizing to the board that they need to take that seriously, because oftentimes there are no records of sexual assault. And the Wilkie memo has some wonderful things in it too. So I recommend when you get one of these cases, print all these out and have them on your desk, because it'll trigger you to remember to include certain arguments and certain language. My favorite from the Wilkie memo is that an honorable discharge does not require flawless service. I love that, because I think the boards operate from that assumption that you have to have been perfect to get an honorable discharge, and that is not true. So it's helpful to point that out. So this is just a little bit more detail about the memos, which I already went into. Again, it really helps if veterans already have a VA disability decision. For those veterans who are not told no by the VA during that character of discharge process, and they actually get to move forward and be granted disability benefits, that's a wonderful piece of evidence to be able to include with the upgrade, to show that the VA, another government agency, found that this veteran's PTSD is related to their military service, not to their childhood trauma or anything else, but related to their military service. That can be really powerful for your upgrade. These are the basic arguments that we use to organize the brief. So did the veteran have a condition or experience that may excuse or mitigate the discharge? That'll be your first section. And then you go into, did that condition exist or did that experience occur during military service? Again, controlling that narrative to emphasize the traumatic experiences that happened while the veteran was in the military. Did that condition or experience excuse or mitigate the discharge? This is the big one that everything hinges on. Because while something bad may have happened to the veteran, the board may not find it, the trauma serious enough to mitigate certain types of misconduct. There are certain things that just can't be mitigated. So back in the days when I was doing these cases by myself, I would sometimes go through thousands of pages of records for a veteran who claimed PTSD based on sexual assault or something like that. And after making it through all the records, I see that the veteran was the base drug dealer. Nothing is going to mitigate being the base drug dealer or some type of premeditated misconduct like that. It doesn't really matter what happened to you, which there was no evidence of, by the way, in that case. He was just the base drug dealer. So I'm not filing that before the board, because I'm keeping in mind that there are not a lot of attorneys who do this work. And I don't want my name attached to a frivolous case. That is not helpful for anyone. I want the board to take it seriously when they see a case coming from the Veterans Consortium and know we're putting together some strong arguments for that veteran. Doesn't mean they're always going to say yes to us, but it's nice to establish a good reputation for filing cases with merit. And at the end, we say, does that mental health condition outweigh the discharge? So this is the big part that you're trying to convince the board of. Is the mental health condition serious enough that it outweighs the misconduct that led to the discharge? Often it is. Like I said, it's often one-time drug use, trying to self-medicate PTSD symptoms, and that's their only misconduct in 8 years of service. So that's what we're trying to say with these buddy statements and the personal statements and all the evidence. Say that, please, the military judged this veteran by the one thing they did wrong. They did everything else right. They served honorably in combat. They tried their best to, power through PTSD and not admit they had a problem or seek treatment, because that's really not encouraged in the military, and show that their overall military service far outweighs that one instance of misconduct. Liberal consideration, like I said, that doesn't mean they're gonna say yes. They really don't want to say yes, but that's what we're developing evidence about. The big thing, like a point of education for the board, is to emphasize that mental health issues inherently affect behavior and choices. So like I said earlier in the presentation, if you're suffering from untreated bipolar or PTSD or schizophrenia, you cannot conform to military standards. No matter how hard you try to power through, it's going to affect your behavior and choices. And my favorite, an honorable discharge does not require flawless service. So I always highlight that when I'm working on a case, so I don't forget to include that. The severity of misconduct can change over time. Now, this is an argument you can use, like when a veteran was discharged other than honorable for one-time marijuana use. Now, I caution our volunteers, don't go all hippie on this, because there's still zero tolerance in the military. Marijuana is still federally illegal. It's illegal in a lot of states, like where I am. So don't go too crazy with that argument, but you can argue that, what used to be seen as severe drug use misconduct has maybe become a little more acceptable in the civilian world, a little more acceptable given that the veteran served 3 combat tours. Like that was my first case too. It's like the veteran served 10 years, 3 tours in Iraq, had a back injury, and decided to use marijuana. And that's what he got an other than honorable discharge for. So they basically canceled out 10 years of combat service by giving him that other than honorable discharge for a one-time marijuana use. And for him, I was able to use the limited use violation argument. But if I hadn't been able to, I would have been like, come on now. Like when you're weighing 10 years of combat service, post 9/11, one-time marijuana use, can we take mercy on this veteran? That's really harsh. And even though, the military was perfectly within its rights to do that to him, and they are still perfectly within their rights 12 years later to do that, there is zero tolerance. But we can argue that that's really an injustice when you look at the whole picture of the veteran service. Wilkie memo, yes, a lot like the other memos. Again, emphasizing second chances, the whole picture of the veteran service, changes in policy. You got to use whatever you can with these cases. The burden is really on you to make this happen. You can argue that the punishment was too harsh, but again, you probably want to admit that, yes, the military was within their rights to do this. However, it was really harsh. And if they were discharged under today's standards, they would have received heightened mental health screening for military sexual trauma. That would have been taken into account before they got that discharge. And they probably would have gotten a nicer discharge. And you can kind of use that to butter them up. Like there's a recent Navy policy that says, there's all these enhanced screenings for mental health issues. So I say, gosh, this veteran was discharged 15 years ago, which doesn't seem like that long ago, but a lot has changed with regards to our understanding of mental illness and sexual trauma in those 15 years. So you can say, I'm sure if that veteran was serving today, they never would have been kicked out with another than honorable discharge. The Navy would have done all these screenings and they would have sent them to a medical board, or they would have gotten them treatment so they could stay in. So you just kind of use that to butter them up and ask for what you ultimately want, which is that upgrade. Oh goodness, this brings back memories of law school, right? So this is how you can organize your brief. I tend to do more informal memo briefs under 10 pages, because again, I'm focusing on who's my audience. And I want them not to be annoyed with me when I submit like 40 pages. Don't do that. Don't submit a 40-page brief to these boards, because like I said, it's usually not, it's not going to be all attorneys for sure. There might be one attorney on the board, but there might not be any attorneys. So really try to reduce the legalese, use those memos I told you about, use that strong evidence from the veteran, and really focus the story, short, sweet, make it easy for them to say yes. We're not going to go through the hypos because I know there's a lot of questions, and we already went through these two in a previous slide. These are just samples of how to organize your brief, so you can look at those later. But I do want to leave plenty of time for questions. Personal appearance hearings. Depends on what the veteran wants. Again, it's important to know what your veteran's goals are and whether they want to speak to the board or not. They may not want to, and that's okay. You might really want to speak to the board, but it is up to the veteran whether they want to do this or not. Again, these boards are used to seeing veterans who do not have representatives with them. So they really don't want to hear from you, in other words. But your job is to prepare the veteran, try to anticipate what questions might be asked. Some of the boards won't say anything, and like it's just all you asking questions of your veteran about, why they committed misconduct, what the mitigating factors were, referring to evidence in your brief. Some of them will aggressively question both the veteran and the veteran's witnesses. So it's always important to prepare the veteran for that possibility. They may ask kind of offensive questions of veterans. And it's important for that veteran not to take the bait and just try to remain calm and explain what happened and why they regret their misconduct, that sort of thing. So as the attorney, your big part is preparing the veteran as best you can when you don't know what questions are going to be asked. Preparing the opening statement. So again, controlling that narrative, starting to tell the story. And the board really is wanting to hear from the veteran. And then if the veteran wants character witnesses to come, like people who have written buddy statements for them, they can also come to the hearings. And now it's easier that you don't have to travel to DC. You can do a video or telephone hearing. But the board may also aggressively question those witnesses. So just warn them of that. And then you're doing a closing statement to wrap it up. And then you have to wait a few months for the decision. Application preparation, we went through this before, so I'm going to kind of skip through this quickly. Again, I've talked a lot about the story teaser, like how to capture the board's attention at the beginning. Fill out the one-page form and then develop all those wonderful exhibits you're going to attach. Then there's a long wait. So it takes a while to put these cases together, like I said, to get the records, for us to review them, and for us to get it ready to send to the volunteer. Then the volunteer works on it, takes a couple months, we hope. Our goal is 2 to 3 months to get a case ready to go to the board. And then we print everything out, label the exhibits and mail it to the board so the volunteers don't have to deal with that part. And then it's 12 to 36 months for a decision. It varies by board, varies by how busy they are. There's still a COVID backlog. So I imagine we're going to see wait times towards the longer end. So again, that's really hard to tell veterans who don't have health care or benefits that, okay, we filed it, now it's going to be 1 year to 3 years. All you can do is keep in touch with them, let them know you're thinking of them. I bug the board usually every 6 months to see if there's an update, and I usually get a response like, we told you it was gonna be a few years. But just make sure they don't forget about your case. Sometimes the boards will order a medical advisory opinion. Sometimes it's favorable, then you don't have to worry about rebutting it. But if it's negative, you'll have 30 days to rebut it. So at that point, you may want to ask for an independent medical opinion, ask for an extension to rebut it, and we can help with that. Sometimes the law firms will donate the funding to pay for a medical opinion, and those can be really helpful. We'll let you know in a case when we send it to you whether we think it's going to need one or not. Sometimes the veteran may already have that VA disability decision and a medical opinion that's really helpful. So we'll handle that if we need to. Vet Center is a super helpful resource. So this is a free counseling center, and they're social workers, so they're not doctors, but they provide free counseling to combat veterans and their families, and also survivors of military sexual trauma. Great resource. I put the website so you can search for one nearest to the veteran that you're helping. They're typically in every county, I believe. 211 is also good to know of your local resources for veterans. So even if a veteran is not eligible for VA benefits and healthcare, they may be eligible for healthcare in the community. They may be eligible for veterans housing in the community. I always tell them, just because the VA says no, doesn't mean everyone's going to say no. So give it a try. Got nothing to lose. Thank you, everyone. We made it through and we have time for questions. Yay, we did it. And I'm going to go to the next slide, which has the CLE, so you can write that down. And Alexis was kind enough to get it approved for all sorts of CLE for you all. So this is Florida CLE code, by the way. So thank you all for sticking with us. I appreciate your willingness to learn about this.
Sure is. And we appreciate your willingness to teach us, Christy. You know, it's really important work. It's really complicated. There's a lot of nuances. So, you know, I know every time that I listen to you give a training, I learn something new. And you are right. I will hold you to possible training on in the future on character of service discharge. I have it on my radar. So before we get into the questions, I'll just quickly pop this into the chat. The CLE code is there, but I'll also pop it into the chat for anyone who may be listening or need to access the chat. But that code is 2210828N as in Nancy, and it is 1.5 general and 0.5 mental illness CLE credits, and also some certification credits there. So I did my best, Christy, to try to aggregate what was in the chat because we had some great discourse, folks answering questions. So I tried to separate questions from comments, and I will present the first question that I have up here, which actually was in the Q&A. It says, do you have to be accredited with the VA to assist vets with discharge upgrades?
No, you do not. So that's a wonderful thing. Now, if you were helping them with the character of discharge, you would need to be accredited because that's through the VA. But this is totally separate from the VA. So you just need to be an attorney in good standing to be a volunteer with us. We also welcome non-attorneys. So some firms will have their legal assistants help with cases. That's perfectly okay. And I put my email up on the screen just so people can take that down if you want to reach out in case you're too shy to ask questions during the webinar.
Perfect. And the next question I have here is about the program, and it says, I do some discharge upgrade cases, but sometimes need to refer discharge upgrade cases because of the limits on my capacity. Do you all have a geographic limit? For example, just Florida on the cases that you accept at the Veterans Consortium.
We do not. So this is one of the things I love about working for the Veterans Consortium. It is nationwide. It is technically worldwide. I've gotten some inquiries from Guam, for instance.
Wow.
So it's technically worldwide. So please do send them to us. I think I put the website earlier in the presentation. It's vetsprobono.org, and you'll see a button for discharge upgrades. That'll give you our program criteria, just to give you an idea of the types of cases we take. We also are a very small team. It's just myself, my staff attorney, my pro bono assistant, and then our intake specialist. So it is a team of 4. We do the best we can, but let the veteran know they're not going to have an instant response from us. We try to respond within 2 weeks to all the intakes that come in online, but there's a lot of demand out there.
I was going to say 2 weeks. My goodness, that is not easy. Small team, but mighty team.
Yes. Yes.
All right. So I put vetsprobono.org into the chat. I'll also include that in the follow-up email when with the recording and with all the other information. So the next question I saw here, it was answered in the chat, but I figure it might be good to bring it up. For those of us who are new to this area of law, can you define the acronyms HRC and NAVPERS COM AEYMOUSE?
And thank you for answering that. I think it was Peter who answered it. So yeah, there's all sorts of, that's Human Resources Command. Certain records need to be requested from there. Sometimes you will get sent in a big circle with records requests, which is why it's wonderful we handle all that paperwork for you before you take a case from us. All the different acronyms to send these requests to.
And then the next question I was able to aggregate, it came in at 1242, if that jogs any memory of where we were. Which board can you apply to after 15 years?
That's the Board of Corrections. So the Discharge Review Board is the one that has that very strict 15-year time limit, which I was hoping would be waived by some of these memos. No such luck. So if you've missed that 15 years, and that is more common than you would think, because veterans do not want to think about this, or they may just have no idea they can even apply for an upgrade until that 15 years has passed. Do not worry. There's the Board of Corrections, which has a 3-year time limit, but like I said, it's easy to get that waived. You just do have to ask for them to waive it.
Okie dokie. And so the next question I have is there any way to upgrade a dishonorable discharge that comes by way of a general discharge?
Yes, I think someone answered that, and that was correct. You have to ask for clemency. So that is really where you're asking for the board to take mercy on you. So that's where it's really critical to have positive post-service evidence. When you're arguing clemency, that is pretty much your only argument, is that you have been Mother Teresa since your discharge. That is hard to prove, but be creative.
How do you obtain the regulations in effect at the time of the discharge?
Google. There's also a Veterans Clinics listserv that has compiled those, I believe, in a Dropbox somewhere. So you may be able to ask someone who has access to that Veterans Law School Clinics listserv. Yeah, a lot of Googling. You could probably FOIA it. I haven't tried that before. I've been lazy and used the Dropbox.
Well, those are great resources in thinking about FOIA too, but also the
clinic. And Alexis, I forgot to mention the Discharge Upgrade Manual that just came out last year. I don't know if you can see it, Military Discharge Upgrades. So that was put out by wonderful advocates in this area of practice: Margaret Kuzma, Dana Montalto, Betsy Gwynn, and Daniel Nagan. Highly recommended. If you're trying to do these, I mean, this is the first time there's ever been a manual. It used to be just a few pages at the back of the Veterans Benefits Manual, and then I would just have to look at the Swords to Plowshares website, Veterans Consortium, NVLSP, Connecticut Veterans Center, and piece things together. Now it's all in a lovely manual, which I think is about $100. Well worth the investment, especially when you're new to this area of practice.
All right, and I think I did find a link to that as well. I think I'm putting the right. Okay. If it's not the right one, please let me know.
Let's see. Yes, that's the right one. So you order it on the American Bar website. Thank you, Alexis.
Of course. The limited use violation only works in the Army, correct?
Sadly, yes. Now there's technically ways you can argue it in other branches of service, but it doesn't look promising to me. I did look that up in the Military Discharge Upgrade Manual recently. You can argue it, but there's no nice there's no nice promise that it will be upgraded to honorable like in the Army.
Would appreciate input on the question of whether an applicant should ask for a personal appearance on the first go. I used to encourage applicants to do paper only reviews first, to provide 2 bites at the apple, but haven't lately due to the long waits. Curious about what you think about this issue.
It is a fine balance. It does take a long time. It depends on where they are. If they are about to run out of their 15-year timeline, they're going to have to make a solid choice. Which one do they want? Because they've only got time for one. Because say you choose a records review and they're almost at that 15-year deadline. You file your form before that 15 years expires. It's going to be 2 years before you get a decision. So if it's not the decision you want, you can't go back to the discharge review board. You've got to go up to the higher level. So it is the veteran's choice. I prefer putting everything together on paper. That is a personal preference, but of course, it's up to the veteran. Some veterans really want to be heard by the board and have that chance to tell their story to them. Some would rather not be aggressively questioned about everything they've ever done wrong. So they may want you to just tailor that brief nicely and submit it and hope for the best. And then that can always be a backup if they've got a couple years left in that 15-year deadline. Let's say they've got 3 years left. Go ahead and file that records review. Hope it goes through and gets what the veteran wants. If it doesn't, then you can try again for the personal hearing. So I usually believe in the 2 bites at the apple if at all possible. But when you're getting down to that deadline, they're going to have to make a choice and they're going to have to live with that because they've only got one choice at the end of that timeline.
Got it. So the next question I have, it came in around 102. So right when we came back from the break, it says, can you say again what the rule was where they had to give him an honorable? So I don't know.
That was the limited use violation. So now I'm obsessively checking for that in every case because that was my very first discharge upgrade case. And honestly, I learned about that through a JAG memo that was in the veterans records. I was like, what is this limited use violation? This was all new to me. So I did some research and I thought, no way, there's no way this is going to result in an honorable without any other arguments. It really did. It really did. So it is possible. I look for it all the time. I haven't found it since it's been, 10 years.
So the next question, it was answered, but I'm just going to say it. Can a veteran's conduct in the life after military have a positive impact on their upgrade request? I'm sorry, can a veteran's conduct in life after the military have a positive impact on their upgrade request? And this person said, thank you, you answered my question. I believe it is yes.
It is yes. It's not technically a legal basis upon which to have a discharge upgrade granted, but it's part of the equity and injustice arguments. Say, this veteran, in spite of the bad discharge and not having any benefits, has, gone back to college, had a successful career, raised a family, whatever it is. Just be really creative with that. It can't hurt. I mean, it can hurt if there's bad evidence, but when your veteran has really done amazing things since their service, you've got to include that.
Yeah. And there are quick I have 4 left. Do you have enough time?
Perfect. Yes, of course.
Okay. Can the veteran file a claim for benefits at the same time as a discharge upgrade process to preserve onset?
Yes, they can. And I highly recommend that. I hope one day to have enough capacity to file both for veterans. Right now, I can't, but I do encourage you to, if you're accredited by the VA or you have a trusted local veteran service officer who files good applications for disability, I always do walk the veteran through and let them know, okay, we're filing for disability, but be aware it's going to come to a screeching halt when they see that other than honorable, and you're going to go through that character of discharge process. Because basically you're gathering the same type of evidence to try to convince the VA that their service was honorable for VA purposes and to try to convince the board. And so it can be similar evidence, and you definitely want to make that insanity argument if it applies, and that's in this upgrade manual. That will overcome the statutory and regulatory bar and excuse the veteran's misconduct. So I do see that happening in some states, and that makes me really happy that veterans are getting access to the VA benefits and healthcare. So it's really hard when they're locked out of all that, and then you've got to tell them it's going to be a few years.
Absolutely. All right. Third, three, and then two, one. So three is there any clarification or explanation about the difference between excuse or mitigate versus outweigh the discharge?
No, not really. Again, it depends on the severity of the misconduct. Typically, what we're seeing is one-time drug use. So, it's a little harder to argue mitigation for one-time cocaine use than it is for one-time marijuana use. But you can do it, especially if that was the veteran's only misconduct. It's just a little harder, but it's just same, different words for the same thing. Organize it how you want to. You don't have to repeat yourself a million times. I just had a volunteer ask that, like, could we squish some of these inquiries together in the brief? I said, please do. You don't want to repeat yourself because you're going to annoy the board.
All right. Is the upgrade process the same if a veteran would like to change his discharge to a medical discharge?
Yes, with the caveat that they can only ask for that from the Board of Corrections. So sometimes if the veteran it depends, like if they have an honorable discharge, but they're asking for a medical discharge, then there's no harm in going straight to the Board of Corrections because you don't have to ask for the character discharge to be changed. You just want a different type of discharge. If you have like an other than honorable discharge and you're asking for a medical discharge or retirement, you can actually ask the discharge review board first to change the character of discharge from other than honorable to honorable, and then maybe apply to the Board of Corrections, just so you have those two chances. If you've got two issues there, if you've got a bad discharge and you're arguing it should have been medical discharge or retirement, only the higher level board can do the medical retirement. So you might need a few chances at that. I think NBLSP in DC is specializing in medical discharges and medical retirements. Someone correct me if I'm wrong, but that's the latest that I heard. So that might be a good resource. I really haven't done any of those.
All right. And the last question that came in, I'm putting some stuff in the chat for it, is if one is interested in volunteering with the Veterans Consortium, how do we get started? And I believe I put it in the chat. There's a link, vetsprobono.org, and then the link that I put in should go specific to the volunteer info. But Christy, is there anything else any potential volunteers should know?
Yeah, and if anyone wants to reach out to me, that's perfectly fine, because I will know. I'll have the list from Alexis. I know you already took this training, so I don't need to send you that link, and I can just get you started. Now, I've only been here 11 months now at the Veterans Consortium, and my new method is I prefer to have more than one attorney work on each case if possible. So if you have colleagues who are interested, make sure to share this training with them. Just for backup, a lot of people have changed jobs during COVID, and I hate to see veterans left out hanging in the wind, because then I will just take their cases and finish it. So if you have someone you want to work with, it's helpful just to bounce ideas off of each other. Maybe have one person take the lead on interviewing the veteran, one person take the lead on writing the brief. It's just nice to have some help with it. And of course, myself or my staff attorney, Anna Maria, will be your mentor with any case you take with us. So we'll help you throughout the whole process.
Awesome. And one quick question came in. It was a clarification. What was the organization that helps with upgrades to medical retirement? I did not get the acronym.
Yes, I think that was, let me put it in the chat. Should be nblsp.org. So National Veterans Legal Services Program. So they're some of the people who put together this wonderful manual.
Well, you blew through all the questions, answered them wonderfully as always, Christy. You are truly an expert in your field. Like I said before, I learned so much from you, and every time I do a webinar with you or even just talk to you, I learn something new, not just about veterans work, but about life. And I really love presenting things with you.
I appreciate it. And I am always learning from other experts in the field. So everyone has a different approach to this. I learned that something every time I attend that PLI training, which I think Alexis put the link in for. So everyone has a different way of approaching this, and it's really helpful to learn from everyone. And typically everyone is super helpful. If you have questions, reach out to us. We'd love to talk about this stuff. Like, just set aside an hour because we won't stop talking about this stuff.
Yes, and thank you for mentioning the PLI again. I did put it into the chat. I will include it in the follow-up materials. I also have taken that training multiple years to keep up with my accreditation, and it is fantastic. So not only do you get the recording, you also get I think it's like a 200-page material accompaniment, which is always really helpful. So I also put information about how to sign up for that as a pro bono membership subscription. That way you can get it for free.
Perfect.
And so with that being said, Christy, is there anything else that you wanted to share? You're getting lots of thank yous in the chat, as expected. Anything before we sign off?
No, I appreciate everyone's attention. I appreciate everyone's interest in helping veterans. Like I said, I got into this by accident, so don't feel like you have to be a veteran or know everything about the military. I will be happy to teach you, guide you through this process. There is a lot of need out there. There's a lot of veterans who are really hurting and being locked out of benefits. So I really appreciate you being willing to help. And thank you, Alexis, for hosting this. You did a fabulous job as always.
You're very welcome. Do we want to quickly put out a plug for February 14th? We haven't really marketed it yet because I'm going to be applying for the CLE credit, but we're going to do the statewide naturalization training. I don't know if there's anything that we can say about that.
Yes, my colleague Chesley Roberts here at the Veterans Consortium will be presenting about how to help veterans become U.S. citizens. And if you're wondering how they are not U.S. citizens after serving in the military, you will just have to wait until that training. It's a great training. I highly recommend it.
Awesome. Thank you. And I'm going to quickly just throw that into the chat as well. That registration. Again, folks, don't worry. I will make sure that I include that in the email that will go out to you all within 24 hours from Zoom. As always, you can reach out to me directly for anything you need. Christy's kind enough to give you her contact information, and I know she's an open door. So with that being said, thank you for spending these 2 hours with us. Thank you for all of the work that you do and for learning with us. And Godspeed, go forth.
Thank you, everyone. Happy New Year.
We'll see you at the next one. Happy New Year, everyone.
Bye.
Bye.